So the first couple of days, we are just walking through the lawsuit and seeing how things fit together. But just remember that for every other class, when you read stuff for torts or contracts or even constitutional law, everything except criminal law, these are the steps that all those cases went through before they got to the opinion that you read. So this is kind of the infrastructure of the doctrines that you're learning about. So far we've been through the opening moves, plaintiff's move, defendant's move. Say we have gotten past the answer and we are in the guts of the lawsuit. That's discovery. Discovery is the stage of the lawsuit where the parties give each other the information that they're going to use in prosecuting their litigation. The scope of discovery is covered in Rule 26, which tells you that discovery can include any non-privileged material relevant to any party's claim or defense and proportional to the needs of the case. So let's walk through all of those things. So what does it mean to say non-privileged material? That means that it's not subject to some of the protections, mostly deriving from common law, that we give some kinds of information. So perhaps most famously, the communications between an attorney and a client regarding a case, those are privileged. They can't be discovered. Similarly, there are some restrictions on communications between doctors and their patients, and a few others. We'll cover this a little bit more as we go on, but mostly this is a matter of evidence law. Okay, next item, relevant to the party's claim or defense. So you always have to show that the thing you want to discover, or you have to be able to show that the thing you want to discover is relevant to what you want to argue. That does not mean that it needs to be admissible at trial. So that again is a matter of evidence law, but not all the discovery you're going to get is going to be things that you can show to a jury. But as long as the things that you're asking for are likely to get you to something that you can show to a jury, that falls under the scope of discovery. And finally, it has to be proportional to the needs of the case. That is a new requirement introduced a few years ago through the rules amendment process. And the aim is to prevent people from asking to see information about topics that are so broad that they might be peripherally relevant to the case, but they don't really fall under the heart of it. And the idea here is to protect litigants, and often to protect defendants, against people rifling through all their files without really having a straightforward connection to the lawsuit. We'll see a little bit how that works in the cases that we read for today. Discovery also has limits. So within that scope, there are things that courts are supposed to prevent, kind of abuse of parties. So under Rule 26b(2)(c), the court must limit discovery if it's unreasonably cumulative, duplicative, inconvenient, or delayed, meaning people waited until the very last minute. So the idea here is to prevent discovery from becoming a tool of oppression within the lawsuit. The court also has the discretion to limit to protect a party from unreasonable annoyance, embarrassment, oppression, or unreasonable expenses. So that's, for instance, sometimes parties will ask for very personal information from one another that might be peripherally relevant, but would cause embarrassment that is out of proportion to the relevance, something like that. So courts have a tremendous amount of leeway in determining whether something is unreasonably cumulative or unreasonably annoying. And that's a lot of what parties argue about in the process of litigation. So let's think now about how is it that you prosecute discovery. You have a few central tools. First, you have your required disclosures. So these are pieces of information that you have to provide to the adversary right at the beginning of the case or as soon as you have them, because they are the materials that you will argue to argue your side of the case. So each party has to provide all the information they're planning on using to support their arguments. After that, they ask each other for information, and they use various forms to do that. Rule 33 provides for interrogatories. These are written questions that the adversary has to answer. They're limited in number, and they're best used for opening up avenues of discovery. So, who was on the scene at this time? Okay, once you know the answer to that, you can pursue those people, you can seek information about those people, perhaps seek to talk to them, etc. How do you organize your complaint system in your computers? Okay, once you understand the organization, you know which folders to ask people to search, and so on. Rules 34 and 45 talk about the production of records and things. So these are unlimited, and they basically allow you to ask for relevant documents. So you can use the information, for instance, that you get in your interrogatories to target the kinds of documents that you think are likely to be produced and are likely to be relevant. Rules 30 and 45 talk about depositions. So these are basically interviews taken under oath that become part of the litigation record. These are also limited in number, so you want to be careful about who you ask to depose. And often you'll do depositions significantly after you have some interrogatories and some requests for production, because you already have an idea of who the most relevant people are to talk to. Finally, Rule 35 provides for physical and mental examinations. So for instance, if I'm claiming that the car accident injured me, I may be asked to submit to a physical examination to see what my injury is and what my general state of health is. Similarly, if I'm claiming emotional distress, I might be asked to submit to a psychological evaluation to see how distressed I really am and whether I have, say, a history of emotional distress that might make it less likely that it was the event I'm suing about that caused it, and so on. So these are the basic discovery tools. I've presented them in the order in which they often happen, but note that you're not bound by this order. You can go in guns blazing and have a request for production if you think you already know what you need. And you can do these things simultaneously. So you have a request for production and you also send over interrogatories. They all work together, and it's important to think about how each one can support your use of the others to get all the information that you need in a limited time. What happens if one party has a request for production, say, or a deposition or something like that, and the other party refuses to comply? You can make a motion to compel to the court. Basically asks the court to force the other party to comply with the discovery motion. Note that motions to compel are really the main way that discovery disputes come to the court's attention. Discovery is done basically as a conversation between the parties or the parties' lawyers, mostly without involving the court. So you do not file your interrogatories and requests for production with the court. The court never sees those things until there is a problem with them. Once there's a problem and a party wants to file a motion to compel, they produce their request to the court and explain why they're relevant, why they should be honored, and explain that the other party is failing to honor them. And then there's an argument about whether it's really relevant, whether it's duplicative, whether it's cumbersome, etc. The flip side of a motion to compel is a protective order. So you can ask the court to issue a protective order limiting discovery. So what this tells you is that those items under Rule 26 that set out the scope of discovery, those are the baseline or the background assumption, the default for what discovery can be. But the court can modify that quite a bit, including through protective orders. So the court might, for instance, simply prohibit discovery on a particular topic, or it might limit discovery on that topic to particular items within issues within that topic or types of records within that topic. It can also limit who can see the discovery. So, for instance, in some cases, you might have a situation where only the attorneys can see the discovery and even the party can't and nobody else can. So the court has tremendous discretion in fashioning protective orders and kind of shaping discovery to what the judge thinks the case needs.